The Scopes Monkey Trial. In the summer of 1925, a Tennessee courtroom put a school teacher on trial for a lesson about evolution. But the case was never simply about whether Charles Darwin was right. The jury was not asked to settle science. It was asked whether one teacher had broken a new state law, and whether a legislature could decide which explanation of human origins belonged in a public classroom. The defendant was John T. Scopes, a young teacher in Dayton, Tennessee. The law was the Butler Act, passed only months earlier. It barred Tennessee public schools from teaching that humans descended from a lower order of animals in place of the biblical account of divine creation. The law had barely taken effect when the American Civil Liberties Union offered to support a test case. Dayton had another reason to welcome one. Local leaders believed a nationally watched trial could bring attention, visitors, and money to their small town. According to the Library of Congress, Scopes agreed to admit that he had taught evolution for that test case. He was arrested on May 5, 1925. That beginning matters. The Scopes trial did not emerge from a surprise police investigation or a private classroom complaint. It was a public legal challenge with several audiences already waiting. The town, the ACLU, anti-evolution campaigners, reporters, teachers, churches, and politicians. When the trial opened in Dayton on July 10, the courtroom became a national stage. Clarence Darrow joined Scopes' defense. William Jennings Bryan, a three-time presidential candidate and former Secretary of State, argued for the prosecution. Their names made the case bigger than one teacher and one statute. Yet the legal question before the jury remained narrow. Did Scopes violate the Butler Act? The defense tried to challenge the law and to introduce scientific testimony about evolution. Judge John T. Rolston restricted much of that evidence. That choice shaped the trial's central tension. Outside the courtroom, Americans argued about science, religion, education, and modernity. Inside it, the judge kept pulling the case back toward a criminal charge under Tennessee law. The heat and crowds became part of the story. On one day, the proceedings moved outside under a tent because of the heat and fears for the crowded courtroom floor. In that unusual setting, Darrow questioned Bryan about literal readings of biblical passages. The exchange became the moment most people remember. But it should not erase what happened legally. The judge had not allowed the trial to become a full scientific hearing. The verdict came quickly. After about 9 minutes, the jury found Scopes guilty. He was fined $100. In the immediate sense, Tennessee had won the case it brought. The Butler Act remained on the books, but the story did not end there. Scopes appealed. In 1927, the Tennessee Supreme Court set aside his conviction. The trial judge, not the jury, had imposed a fine above $50. The court upheld the Butler Act itself, so the appeal did not deliver the sweeping constitutional victory that many modern retellings imply. That distinction is the key to the Scopes trial. A conviction disappeared, but the law survived. The courtroom spectacle traveled across the country, but the legal rule remained in Tennessee for decades. The legislature did not repeal the Butler Act until 1967. Why does this case still matter? Because it shows how a classroom can become a constitutional stage long before a court reaches the broad question everyone is watching. It shows how publicity can reshape a local dispute, and it warns us not to confuse the most dramatic exchange in a trial with its actual holding. The Scopes Monkey trial was not a final verdict on science or faith. It was a fight over public education, state power, and the stories a democracy permits its schools to teach. A century later, that question still has not left the classroom.